Please subscribe the channel and hit the bell icon for the future uploads.
Hello everyone. In this part of the video, we are going to see the provisions of judicial separation in Special Marriage Act. So, as far as this topic is concerned, what will be asked in the question paper is discuss the provision of judicial separation under Special Marriage Act, or what are the provisions of judicial separation under Special Marriage Act, write a short note on judicial separation, or discuss the provision and object of judicial separation under Special Marriage Act. Questions asked: what are the provisions for judicial separations in the Special Marriage Act 1954? What is judicial separation? Short note on judicial separation. So, as writing any other question, for this question as well, firstly we have to write introduction part, then what is the judicial separation actually, what are the provisions under which judicial separation is granted, what is the object behind granting judicial separation, whether the judicial separation can be rescinded after it is granted, and then we will write the conclusion part. So to introduce the topic, we have to say that basic object of judiciary system is to save the marriage, and that's why this provision has been evolved so as if the parties live separately from each other for a particular time, they get time to reassess as to where it went wrong, and then they can decide to get back together and rework on their matrimonial life, and that's why judicial separation came into existence. Now, what is judicial separation? Section 23 Special Marriage Act deals with the provisions of judicial separation. Section 23(1) deals with what is judicial separation, and Section 23(2) deals with rescinding the decree passed in Section 23(1). First, we will deal with Section 23(1). So, who can file the case of judicial separation? Either husband or wife can file the case of judicial separation. And what are the grounds? First of all, both of them can file the case for judicial separation on the ground that if there is a decree passed for restitution of conjugal rights, and after that there is no resumption of cohabitation between the parties, then either husband or wife can approach the court to ask the relief of judicial separation. So what does it mean? If husband or wife has made a petition for restitution of conjugal rights, which was allowed by the court, and once the decree is granted by the court, still the parties have not resumed cohabitation between them, and therefore on this ground either husband or wife can approach the court to ask such relief. Next, husband can file for judicial separation for the grounds enumerated in Section 27(1). So grounds available for husband under Section 27(1), he can file the same on the same grounds as far as judicial separation is concerned, and for the wife, the grounds enumerated in Section 27(1)(a), which are available to the wife, that is additional relief available to the wife. So a wife can file a petition for judicial separation on grounds on 27(1) and 27(1)(a). So she has she has two additional grounds as far as Section 27(1)(a) is concerned, under which she can also file for judicial separation. So husband or wife can file for a decree of judicial separation. Judicial separation, Section 23(1) can be filed by either of the spouse. Both the husband and wife can file on the ground of non-compliance of decree of restitution of conjugal rights. Husband can file the petition for judicial separation on the grounds mentioned in 27(1). Wife can file the petition for judicial separation on the grounds mentioned in 27(1) and 27(1)(a). Next part of the answer will be what is the effect once the decree is granted in the favor of the spouse. Basically, the effect of judicial separation is the right of cohabitation is stayed. In the matrimony, there are various rights like right of maintenance, right of living together, that is right of cohabitation, right to have a child, right of custody, right of property. There are various rights, but only the right of cohabitation between the parties is stayed, and the parties is given cooling time to decide what went wrong. So all the other rights survive, only the right of cohabitation is stayed by the court. This is the important effect. You have to mention this in your answer, without which the answer on judicial separation is not complete. Effect of the decree of judicial separation. If the decree of judicial separation is passed, the right of cohabitation of the parties is stayed. All the other rights in the matrimony like maintenance, custody of children, etc. are intact. Now, in this part of the answer, we have to state what is the main object behind granting such decree. The object goes to the core of the concept of marriages and the judicial system. The very object of establishing a court or family court is to save the marriage. And with this same object evolved the concept of judicial separation, whereby the parties are rather decreed to live separately for a certain period so that they can think what went wrong, they can rework on their marriages, they get time to cool off, they get time to reassess the situation and work out on the matrimonial life so that they can start their life and live their life happily ever after. This is the basic object behind passing the decree of judicial separation. Object of judicial separation. Main object behind the principles of judicial separation is to save the matrimony, to give parties time and some space to work out as to what went wrong and rework on the marriage. This enables parties to live separately from each other and to see what was the actual dispute, which things were not acceptable, and to reassess the situation. Section 23, which deals with judicial separation, has subsection 2. It deals with rescinding the decree passed of judicial separation so that a spouse can approach the court, make an application that the order or decree passed under judicial separation may kindly be rescinded. The spouse has to give some answers as to why such decree needs to be rescinded, and the court, being satisfied that there is a ground, may rescind such decree passed by the same honorable court. Rescinding the decree, section 23 subsection 2. On an application made to the court, being satisfied with the statement, the court may rescind the decree of judicial separation. Like any other answer, this answer also will not be complete without writing the conclusion part. Now, we have covered almost all the things enumerated in section 23, and if you write all these things, definitely you will score better marks than the other students. Now, while writing conclusion, we have to say that in order to save the marriage, the legislature has incorporated the special provision of judicial separation under section 23, whereby the parties live separately from each other for some time, reassess the situation, rework on the things which went wrong, and start their matrimonial life afresh to lead the happy married life. This will be the conclusion, short and sweet. The same video in Marathi language is also uploaded on YouTube, the link of which is given in the description box down below. Also, if you have any questions or queries, please put them in the comment section so that I will answer.
If you have liked the video, please give a thumbs up. Video on various topics are going to be uploaded on YouTube. Please subscribe the channel and hit the bell icon for the future uploads. Thank you.